My Lord, all that my colleagues did was to take the state heads and then to criticize them. However, at the heart of the criticism of the state's argument, there's this golden thread, my Lord, that they categorize the evidence of Ms. Fillingham and Colonel Steyn regarding the two calls as they put it, my Lord, as a contradiction. We submit, my Lord, that this demonstrates a fundamental misunderstanding, as we printed out in our heads, of the nature of and we say this with the greatest of respect, this demonstrates the fundamental misunderstanding of the evidence of Ms. Fillingham and Colonel Steyn. We submit, my Lord, with the greatest of respect, that there's obfuscation of the role of Ms. Fillingham as a forensic officer of a service provider of call data with the role of Lieutenant Colonel Steyn as an analyst. An analyst of an instrument, a cell phone, and accessing the downloads on the phone to which the service provider doesn't have access to these downloads. It's only Colonel Steyn as an analyst who's got access to these downloads and who can testify about it. Now, my Lord, to then categorize the evidence of the two witnesses as a contradiction on this point, as we've argued, my Lord, demonstrate a fundamental misunderstanding of their evidence, and Colonel Steyn is available, my Lord, to clear up this misconception, to clear up this misunderstanding. And as we've submitted yesterday, my Lord, it's in the interest of justice that he should be recalled to come and clarify this aspect so that we are all on the same page. And my Lord, it is this fundamental misconception that has led to him being accused of fraud, of uttering, and it is this fundamental misconception, my Lord, that has led to this personal attack on Colonel Steyn. And the state views this attack in a serious light, so much so that we had to drag him out of retirement, mindful of what Advocate Mshololo said. He's retired, my Lord, but the allegations that have been leveled against him are so serious that they cannot be left unchallenged. And even if he's in retirement with all the old age ailments, we had to drag him out of retirement, my Lord, to come and clarify these issues, because it's in the interest of justice, my Lord, that they be clarified. We've been criticized, especially by Advocate Mnisi, that we should have dealt with these contradictions. But as we've just indicated, my Lord, that viewed in the proper context, these are not contradictions. Each is testifying about the information that is applicable in their area of expertise. Lieutenant Colonel Steyn concluded his evidence on the 1st of August 2023 And Advocate Nisi was referring to Exhibit J1, the statement of Ms. Faithillingham, which clearly states that it was deposed to on the 16th of May, 2024. So this, the evidence of Ms. Faithillingham came much later after the conclusion of the evidence of Colonel Steyn on the 1st of August 2023. Mr. Ngumalo argued that these are issues that can be addressed in argument, but we submit, my lord, that if there's such a fundamental misunderstanding of the evidence of the two witnesses, this is the issue that cannot be addressed during argument. We therefore submit, my lord, that the application ought to be granted. Advocate Mshololo said, argued that the state is asking the court to invoke Section 167. On the contrary, my lord, we have stated clearly in the heads that this is a rule of practice. We have, in the meantime, found that the case that the court was referring to of David King, case number 86/09, and judgment was delivered on the 8th of March 2010 by the Supreme Court of Appeal. And what the court said in this judgment is already contained in the heads of the state. On page 4, paragraph 5, the court said the following: there is no such thing as perfect justice, a system where an accused person should be shown every scintilla of information that might be useful to his defense, and discovery in criminal cases must always be a compromise. And this is the portion that we quoted in our heads. Fairness is not a one-way street, conferring an unlimited right on an accused to demand the most favorable possible treatment, but also requires fairness to the public as represented by the state. This does not mean that the accused's right should be subordinated to the public interest in the protection and suppression of crime. However, the purpose of the fair trial provision is not to make it impracticable to conduct a prosecution. The fair trial right does not mean a predilection for technical niceties and ingenious legal stratagems. We submit, my lord, with the greatest of respect that this is an instance where the interest of justice trumps any other consideration. When Advocate Mshololo referred to the fact that the state is invoking, or is asking the court to invoke Section 167, we merely quoted Section 167 to indicate, my lord, that the application of the state is not an unusual occurrence. There's already provision for such a procedure in our law. We therefore, my lord, request that the application be granted.
Yeah, that's for my education, if there is a lack of it. Can legal representatives, meaning the state, can the state and also the defense invoke Section 167 or 186 and persuade the court, or extol that persuasion to the court to say, the court is entitled or can invoke Section 167 or 186, not out of its own mero moto? Are you with me?
Yes, indeed, my lord.
Is it legal? Let's hear Mr. Ngomezulu first, or Mr. Myeki first.
Yes. Yes.
Can litigants, represented litigants by the state and by the prosecutor and by the defense, implore a court to exercise its own.
I hear the court.
Oh, you have heard it?
I hear the
Thank you.
My Lord, in all the cases
Yeah.
that we researched
Yeah.
yesterday after this application was made, actually they indicate that it is actually the court that can invoke that section to recall a witness that has not, to clarify any evidence or to clarify any issue that has arisen during the...
Yeah, I've heard you, but you see, you're investing the logic.
Yes,
I know it is, the Act says I can do it.
yes.
167
Yeah, but-
and 186. But can you, because
in-
you feel your client is being shortchanged.
In terms,
That's,
in terms
and then
of
this
the,
judge is so stupid, he doesn't see this point.
in
And you
terms
make
of
an
the-
application that, judge, invoke section 167.
in terms
That's
of
what I'm
the-
asking.
In terms of the case law that is available, my lord,
Yes.
that is unknown. It has
Unknown,
not- yeah,
okay.
I have not come across case law that actually shows that the state or the defense can actually recall the witness to close the lacuna in a case.
Okay, Mr. Mnisi, sorry, Ramsepidi, you agree with your colleague?
As the court pleases, my lord. My lord, stricto sensu, it
Okay.
says, in the strictest terms of the act, it says the court may recall a witness for clarification purposes, my lord. However, in answering the court's question, in the Shabir Sheikh matter, it was the defense that recalled a witness for clarification, my lord.
Okay, fine, no, I'm aware of the case. Mr. Mnisi, educate me.
By convention, I think there is no impediment from one of the litigants to request the court, and the court can then use its discretion.
That's it. Happens every day, no? You're right. Yeah. Let's hear, unless Mr. Ngomalo and Mr. Mshololo say you are wrong.
No, I'm not saying it's wrong.
No, okay, fine, what do you say?
The court can use its own discretion on the application.
No, but you're not listening to Mr. Mnisi. Tell him what you said, Mr. Mted, tell him what you said. Repeat what you said. I don't think he understood you.
I understand.
Mr. Ngomalo, I mean Mr. Mnisi, yeah. Just repeat what you said before, just before now. By convention, that's the... No. Once you have said it, he'll understand it. He didn't catch you. I but
I've said, my lord, by convention, there is no impediment on the part of the litigants to request the court or to make an application or to ask for an indictment from the court to record a particular witness. And then the court in those instances can then exercise their own discretion.
Okay, fine. Ngomalo,
I'll fall in the same trap, my lord.
you follow?
I agree with my colleague.
Okay, all right.
Yes, I agree with my colleague fully.
Ms. Mshololo?
My lord, both these provisions, they are very clear.
Deba?
They are very clear
Okay.
to say the court may. It doesn't say any party during the proceedings.
No, you've missed the ball again.
Yes, my lord.
The court, the duty rests with the court.
Yes, my lord.
Now, the incantation by the defense, when they realize that they want the court to exercise its discretion in terms of 167 and 186, can they argue and persuade the court to utilize that discretion which rests on the court? That's the question.
My lord, can I make my submission?
Yes.
Okay. My lord, my first submission is that the section is clear. 167 says the court may. 186 says the court may. That's my submission, my lord.
We're fine.
These two provisions says the court may. It doesn't say any party. However, my lord, if it is at the instance of any of the party, either between the state or by the defense, the court must use its discretion.
Okay, fine.
Yes, those are my submissions, my lord. to
Okay,
say.
thank you.
No,
Yes,
the
Miss-
act, it's very clear to say it's the court, not by any party.
Okay, Mr.
Thank you.
Baloyi, any new wisdom?
As a court, please, I go along with the submissions of all counsel. I think we are all at idiom that any party can request the court to invoke these provisions.
Okay, what's the time now?
It's 11:05.
Yeah, okay, let's come it up.